went into the door?
No, what happened was he shot at me 6 times. He had a 22 on a 44 frame. He shot at me 6 times. Well, and I was standing in my driveway, and then he was pulling off. Then I shot a round through his back glass, and then I shot a round through the back glass through the front glass. Then I put a round in his toolbox, and then a round in his tailgate, and then he started pulling out, and I put 2 rounds in the bottom crease of the door, and they were hollow points. So that's the only thing that they explode when they hit something, so they didn't penetrate into his cab.
17 years ago, this man lost his Second Amendment right when he became a felon for what he claims was a self-defense incident. Now he is facing the Commutation and Pardon Board of Paroles in Louisiana to receive a pardon with the restoration of his firearms. Let's watch this hearing and see the results.
Mr. Jones, your DOC number is 531572. You're here today seeking a pardon with restoration of firearms. You were sentenced in the 9th Judicial District, Rapides Parish, in December 2007, 2 counts for aggravated assault with a firearm. Excuse me, you received a 5-year sentence that was suspended, and you were placed on 5 years active supervised probation. Is that information correct?
Yes, ma'am.
All right, would you answer Mr. Prater's questions, please?
Yes, sir. Mr. Jones, would you tell me about the evening and early morning in 2006 where you were arrested? Because I've got some conflicting things, or it seemed to be conflicting. So tell me about that from your viewpoint. What happened?
Yes, sir. I was at my home at 4:00 a.m. and I was awakened by abrupt beating on my door. Sounded like they were beating it in. And I answered the door, and I was jumped on by one of the people who was there, and I threw them off of me 3 times. They scratched my face and stuff. And then a guy that I told not to show up here showed up with a pistol tucked in his pants, and he proceeded to act like he wanted to fight. And I looked at him and seen he had a pistol, so I backed up in my house and got my pistol. And by the time I got back out, he had jumped in his car and started shooting at me. And then I told him he better leave, or I was going to show him how to shoot. And then I fired back at him, and I wasn't intended to kill him or nothing, or hit him. I was just firing at his truck, and I hit everything I was aiming at, and he pulled off, and they went to the UP Long. I heard everything after that is hearsay. That's actually all I can tell you. It was 4:00 in the morning. I was awakened and assaulted, and I was shot at first, and I returned fire to run them off. That was all I intended to do. I didn't intend to, shoot anyone, and I didn't. And then I came back in the house, and SWAT team showed up, and I guess took a couple of hours for them to talk me into giving up. But I did without any incident. And then that's about all I can tell you about that night and early that morning, Sunday morning, I believe it was.
Okay, y'all been out at the one, okay. When you were assaulted, when you were abruptly awakened, you were assaulted by a male or a female?
That was a female.
Okay, did you know this female?
Yes, sir.
Had you been drinking with that female earlier in the evening at the same bar?
No, I hadn't been drinking. I was there with her, but I was on a motorcycle and I don't drink while I was on a motorcycle. When I got home, I broke open a gallon of scotch and started drinking when I got home about 11 o'clock that evening. And I passed out here at the house, and then I was awakened at 4 o'clock in the morning.
Okay.
When I answered the door, she had a knife on her. She had gotten dressed that evening and put a knife on her. I seen that, and then when I seen he was armed with a gun, after I'd thrown her off of me about 3 times, she was, beating on me. Then,
Okay,
I knew they both were armed.
okay, and so you knew the second assailant also?
No, I met him at the bar that night because she was getting out of the truck with him, and she had told me that was her boyfriend, who she was getting crack for, and he was using her to buy his crack and to have a threesome with him and another individual on crack. And I was trying to help her out because I knew her grandfather was a friend of mine, been a friend of mine since I was 14, and I was trying to get her off of that stuff.
Okay, so that the board, I'm sure they've read this, so that the board and the public that might be watching this understands, you had been living with this assailant, this person that abruptly woke you up. You'd been living with her, correct?
No, she had been in my house for about a week.
Okay, so you'd been living with her for about a week. And you took her items and you put them in something and put them on the porch for her to pick up, correct?
That's correct.
So you knew she was gonna come by there.
I told him to come by the next day. I told him never to come here.
Okay, all right, well, I don't want to get too lengthy with all this and I'm just trying to understand the situation. They abruptly woke you up, attacked you, and next thing you know, you're going back into your house. So after they abruptly woke you up and attacked you, all of a sudden you're outside. How did that happen? To where
No,
you have to go
I
back
answered.
inside to get your gun?
Yeah, that's what I did. I stepped back in my house to get my gun out of the drawer right next to my door because I seen he was armed.
So what I'm saying is when you were awakened abruptly and attacked, normally that occurs inside your home. Somebody has pushed their way in or shoved their way, but y'all are outside.
No, yeah, I answered the door. I was in
And
my doorway.
outside.
I was in my doorway in the carport.
Okay. All right. So you went back and you didn't mean to, you shot it, you hit what you aimed at,
He
But
shot
you-
at me. Excuse
but
me,
you
sir.
didn't want to hurt him. But according to the police reports, you knocked out the passenger side glass, 3 shots went through there and some went into the door.
No, what happened was he shot at me 6 times. He had a 22 on a 44 frame. He shot at me 6 times. Well, and I was standing in my driveway, and then he was pulling off. Then I shot a round through his back glass, and then I shot a round through the back glass through the front glass. Then I put a round in his toolbox, and then a round in his tailgate, and then he started pulling out, and I put 2 rounds in the bottom crease of the door, and they were hollow points. So that's the only thing that they explode when they hit something, so they didn't penetrate into his cab. And that's exactly where my rounds went. And he was shooting rounds all around me, 6 times before I ever fired the first round.
Okay, there was some discussion about whether you choked this assailant. Did you ever choke?
I never choked on. I never put my hands on her.
Okay.
I threw her off of me. She kept assaulting me and beating on me and scratching me, and I just grabbed her and threw her off of me. I never choked her. I never did anything aggressive to her, but defend myself. Tried to throw her off of me 3 times.
All right, well, we'll move on, but the reason that you want this is for restoration of firearms, because you're a gunsmith or want to be a gunsmith, and you want add deer meat to your diet. Is that correct? Is that the reason you want it, so you can hunt and work on guns?
Yes, sir. And I was also thinking about opening up a rifle range to supplement my income.
Okay. I think I've heard enough. Let's see, turn to you.
All right, Mr. Frank.
Okay, when she was jumping on you, were y'all outside under the carport, in the door, or in the house?
Yeah, I stepped out right outside my door in the carport. I was under the carport.
How did her body end up in the street?
I don't know. She was laying up here by the car. I fired a warning shot in the concrete, and I understand some of the concrete shattered on her, and she claimed that I shot her, but I didn't. And then the guy was started shooting at me, and she was laying up here in my carport.
So you fired the first shot, it was a warning shot.
Yeah, it was a warning shot in the ground. I had just went through training at Angola for a correction officer. I was a firefighter EMT correction officer at Angola prior to that, and they had taught me not to fire a warning shot in the air, to fire it in the ground. Well, I was under the carport and it hit concrete, and the concrete splattered, and she had thought that I had shot her, but it was the concrete had hit her that from my warning shot. And then he started shooting at me, and as I walked down the driveway and he started pulling off, that's when I shot his truck up.
Okay, I don't need anything further.
Ms. Stapleton, go ahead.
Yeah, I've got a question. You said that it took the SWAT team coming there in about 2 hours to calm you down to come outside. Did I hear you correctly when you said that?
Yes, ma'am.
So why did you not come out for the SWAT team? You knew you were safe with them.
Pardon me?
I mean, with a SWAT team, you knew it was police, you knew it was SWAT, so there was no reason to fear that they would just massacre you when you walked outside. Why didn't you come on out? So that this thing.
I had drank about a half a gallon of scotch when I got home, and I wasn't thinking properly.
Okay.
You know, I'm not trying to excuse myself. I realize I did have a lapse of judgment that, you know, and I was intoxicated at the time, and I wasn't thinking clearly.
Okay.
And I don't drink no more, and you know, my favorite food is venison, and I was just wanting to. I don't have any assault weapons. I've got old classic guns. The most modern gun I have is a Remington 742 Woodmaster 30-06, and I have old shotguns and guns I inherited from my father, and guns that I had collected, like Winchester's old 1892 Winchesters, and handguns, revolvers, and I don't have any assault weapons or any automatic weapons. I haven't seen my guns in a long time. It's been 17 years since I had even seen them or cleaned them. I haven't touched a gun. I haven't even gotten a traffic ticket or nothing. I'm a law-abiding citizen, and I just want my gun rights back so I can hunt before I get too old.
Thank you, sir.
So, Mr. Jones, where are your guns?
Well, I left them with a friend of mine who had died, and his wife, I think, sent them to her son-in-law's house now. I believe they're there. Some of them anyway. I believe some of them are missing.
All right, so just so I was a little confused when you were talking about all the different variety of weapons that you had, that you don't actually possess those.
Oh, no,
So-
ma'am. There's no guns here at my
I
house.
wanted to, okay, I just wanted to clarify that. Are you
I
a
haven't
veteran?
had, it's been said, yes, ma'am. I haven't had them guns. I haven't even seen them in 17 years.
All
I'm
right,
not even sure if they're all still around.
so you're a Navy veteran?
Yes, ma'am.
All
I was
right,
on the,
thank you
U-
for your
I was on the,
service.
U- pardon me.
Thank you for your service.
I appreciate you saying that.
Right. I don't see any other questions by my colleagues. We'd like to hear from Mr. Johnson with the DA's office, please.
Is that the DA's office here in Ellick?
Yes, he's on the phone. He's gonna tune in. Just, is he there with us still? Coming in now.
Yes, I'm here.
All right, Mr. Johnson, what would you like us to know?
Well, our office still remains in the stance that we are against Mr. Jones getting his gun privileges back due to the nature and the crime that he committed when he was found guilty of that. Nothing has been said today that has changed our stance.
All right, well, thank you, Mr. Johnson. We appreciate the input.
Yes, ma'am.
Mr. Jones, before we vote, is there anything you'd like to say to the board?
Well, like I said, I'm not trying to come up with any excuses. There's no reason why Mr. Johnson should have any reasons why he shouldn't allow me to have my gun rights back. I mean, I've been a law-abiding citizen. I haven't even gotten a traffic ticket. And I'd just like this to be over where I could clean my guns and get them back and to go hunting for venison again and continue as a law-abiding citizen that I have been. And as far as the guilty plea for the charges, I did that because my lawyer gave me ineffective counsel and spent more time trying to talk me into making a plea bargain than to because he didn't want to spend the time doing a trial jury, which it should have been done. But he had me so worried about going to jail for 45 years or so that he talked me into pleading guilty, which I shouldn't have done. And
Yes, sir.
because
Yes,
I
sir.
was standing,
We are prepared to vote now. We're gonna go ahead and vote, and Mr. Prater will be voting first.
Yes, sir. How old were you when this occurred?
I was 49 or 50.
Okay, all right. Due to a number of things I've heard today, and we have to make decisions on behalf of what we think is best for the individual, but we also weigh what is best for the public also. And I'm not convinced that something like this couldn't happen again. And I'm gonna vote to deny.
Mr. Freeman?
There's a lot of inconsistencies in the story, and a weapon was used. Even if I was to think about granting, I would not allow you to have a weapon. But I agree with Mr. Prater. My vote is to deny.
Mr. Tillis?
My vote's deny also.
Ms. Stapleton?
I agree. I to deny.
All right, Mr. Jones, I do agree. There's some concerning conversation that I heard today. My vote today also is to deny. So, sir, your application for clemency has been denied this morning. Good luck to you, sir.
Do I?
Well, the man leading this interview, Mr. Steve Prater, was the sheriff of Louisiana, Shreveport, for quite some time. And he was running this interview, and I don't think there could have been a better person for it. It kind of reminds me of Grady Judd, right, from Florida sheriff. So and we'll watch this little insert of him, Steve Prater, in a second, but let's just unpack this. I am a Second Amendment person. I think it is critically important. And I also feel for this man. I do believe that, he's a gunsmith. I do believe he wants to hunt. I do believe in those different things. But then you also have to take a step back and look at the story that you were told and look at, wow, this is dangerous. I mean, the bottom line is that he shoots at a woman and a man that comes to his house, and then he makes the claim that he wasn't trying to hurt them, which as far as I've been trained, I've been told, you don't shoot at anything unless you're looking to destroy it. Now, I get that he brought in that he was being trained as an Angola prison guard, and they probably do have different training protocols than the average person, and that's his excuse or prerogative, but it doesn't make me feel any better. And he's trying to make himself also seem like it was all predetermined. Or, well, it was hollow points, it could have never gone in, and I aimed at this and I aimed at that. And let's not forget that he's also talking about this woman, but really a girl who's the age of his grandchild. He's referring to him being close friends with her grandfather since they were like 12 years old. So that means she's the age of the grandchild. He took her into his house for a week. He's trying to make it seem like it was all this innocent thing. And I'm sorry, I just have a hard time believing that it was anything but that. What he needed was an attorney, because the more he spoke, the deeper he dug himself, in my opinion, into the deeper he dug his hole. He needed an attorney, and he needed to just shut up. And even then, I don't think it would have gotten him much. And he's blaming his attorney for not going to trial. And just from hearing the facts of this case, that was probably the best move he ever did. He got a sweetheart deal, 5 years, probation. This could have gone ugly real quick. Now, even starting off with, well, I was riding my motorcycle. I didn't drink at the bar, but I came home and I opened up a gallon of whiskey and then drank half a gallon, and went also, like, just the idea that when the SWAT team came, that he had a standoff with the SWAT team for 2 hours. And blaming it on, well, I drank half a gallon of whiskey. It's like, you're coming here asking Louisiana to trust you. You just didn't give them anything. What's unique about, Richard was able to find on this case, one unique thing. This guy's been kind of, well, here's what was found, and it's that he was a volunteer firefighter, maybe around the time that this happened or something like that. And he crashed when driving his fire truck. Wasn't a volunteer. He was employed as a driver. And he was there for 3 years when he crashed into a postal truck. And I guess it was standard protocol at that time to do a drug test. So he peed into a cup, and they said, well, there's something wrong with the urine. Pee again. And he then was upset and didn't want to do it. So they fired him. And he said that it was illegal to fire him. He ran an appeal. The court found that he was right and reinstated his job and retroactive pay for all the months that he missed pay. So it would have been a nice little payday. And then I guess imagine working at the fire station if he did take the job back for how long of a period of time with people that fired you. That's got to be awkward. But he won that case. And hey, I mean, it is what it is, right? But let's go look at the old sheriff.
This past weekend in Shreveport, we had a 10-month-old baby shot. We also had another man that was shot and killed and found in the street. And there were other shootings. Aren't you tired of the violence in Shreveport, Louisiana? I am. Over the last 2 years, we have booked 75 people into our jail for murder. Of those 75 people, 49 were convicted felons. They should not have had a firearm. I've introduced Senate Bill 188, authored by Senator Bodie White in the state legislature, that's going to help do something about that. What that bill does is add illegal possession of a firearm by a convicted felon to the violent crime list to increase the penalty, increase the time a person will have to serve. If a felon who knows they're not supposed to have a gun goes and gets a gun, then that should be a separate law in itself, and they should be held accountable. That's why this Senate bill was authored and introduced. It needs to pass. That's just the first step. There's other things that we need to do. Representative Bagley introduced House concurrent resolution that will cause the state of Louisiana to look at the homicides for the last 5 years and to determine what the common denominators are as far as the person that committed the homicide and what kind of criminal background, criminal record they have, how many breaks they've had, and what we possibly could have done as a society to keep them segregated from the people that will abide by the law.
Well, there gives you a taste. So here's a sheriff that made an initiative to make a bill that would make it, I guess, a harsher punishment for anyone using a crime who is a felon with a weapon. It's just an interesting note of fact is that that bill did make it to the floor. It was voted on by a large constituency, and the governor at the time vetoed it. John Bell Edwards, who's no longer governor. The new governor, who handpicked the sheriff to be on the parole board, who we just saw, I imagine when this bill is put back into regular session, will sign it. But it seemed that the bill had gotten many signatures, but then it was vetoed, which is just classic politics for you, right? Attorney to compel the court to determine whether the defendant is a dangerous offender when filing a bill of information. Such piece of legislation is unnecessary as provisions governing the calculation of sentences and parole eligibility based on one's prior history of felony convictions existence current under law. Therefore, Bill 188 is not needed and should not become law. For this reason, I have vetoed the bill. And just a little look under the hood of insanity, in my opinion. It's like, wait a minute. If you're a felon and you now commit a crime with a gun, you shouldn't have some type of mandatory punishment for it. Make it make sense. I mean, I get it. I'm against mandatory punishments as well. I think it can lead to lots of problems, but it doesn't hurt to have some type of enhancement. Anyways, that was the first. We're going to go watch more of these hearings. Thank you, Richard, for providing the info. What do you think? Do you think he should have gotten his gun rights back? Not with that interview. That was scary. And with that, before we go, I almost forgot to mention it. He did start talking about all his guns as if it was my guns. And then he's mid-sentence, he realizes, and they catch on. They're like, wait a minute, when was the last time you saw your guns? And then he's like, I haven't seen them in a long time. I don't even know if they're all still there. Oh, it's my friends. And it's like, please. I mean, you're talking about guns that your father handed down to you. You're talking about the models. Like, oh man, that was actually interesting. Okay. Anyways, let's jump to the next one.
Hold on, that one. No, you haven't. Can you hear us okay?
Yeah, I can hear you pretty good.
Okay, I need you to stop moving because you're making us dizzy.
Yes, ma'am.
Okay. Mr. Sabatier, let's see. There you Your DOC number is 554613. You're here today seeking a pardon with restoration of firearms. You were sentenced in Orleans Parish. Let's see, first in June of 2009. And then you have another sentencing date, June 18th of 2013. Both were for possession of marijuana. On the first one in June of 2009, you received a 5-year DOC sentence that was suspended. You were placed on active supervised probation. The second conviction, also possession of marijuana, you received a 3-year DOC sentence that also was suspended and you were placed on active supervised probation. Is all that correct?
Correct.
Okay. Would you answer Mr. Freeman, please?
Okay, Mr. Sabatier, you know, what was the deal? Why were you, selling dope or having dope all the time?
I was just young and being a follower, man. As I look back on it, I honestly call it a product of your environment.
All right. Have you ever been married, Mr. Sabatier?
Hey, you said, have I ever been married?
Right.
No, I'm currently engaged.
Okay. And you're 34 years old?
I'm 33. I'll be 34 in August.
Okay, birthday coming up soon. Did you ever pay your balance to probation pro?
Yep. All my fees and everything should be paid off. They wouldn't have let me off parole. They wouldn't have let me off probation if I wouldn't have paid those fees.
Why you need this expungement? What do you need it for?
To be honest, I already have my record expunged, so I pretty much have a clear record. And the only reason I really applied for the pardon is because I really want my gun rights restored. And it's not the fact that I actually need a gun. It's just me having a clean record and staying out of trouble for so long. It's just the fact that if I ever wanted to purchase a gun, I can't. Because of some well, I don't want to say it's minor weed charges because it was definitely a felony convictions, but it's non-violent offenses. That's no longer on my record already.
Have you ever been in any treatment for drugs, alcohol?
I did do drug court. When I was on the 5 years probation, I did drug court.
Did you complete it?
Yep, I definitely completed it, got the certificate and everything.
Okay, so you graduated from drug court. Okay, let me ask you this. I saw where, and you were being honest, that at the time of the investigation, which was a while back, that you said you had smoked marijuana 6 months ago. When's the last time you smoked?
It's been a while, man. I haven't been smoking.
Okay, how long?
I would say at least a year and a half, maybe 2 years.
Okay. All right, I have no fucking question.
Okay. Were you on probation at the time you got the second arrest?
No, I wasn't. They thought I
Yeah.
was on probation, but I wasn't on probation when I got the second arrest.
So you did the drug court and all that, and then you
Yes, ma'am.
kept doing the same thing? Yes?
Yes.
You got rearrested. So tell me, for your first arrest or conviction rather, in 2009, how much marijuana was in your possession?
Maybe like 4 grams.
And what about the second time?
The second time I had like maybe 2 grams.
So you were selling it?
Not, if I'm being totally honest, I was smoking.
Yeah, so that was just for your own use?
Yeah, and the first time I believe they charged me with possession with attempt to distribute, but it was literally like 3 bags of marijuana.
All right, and so you still live in New Orleans. Where are you employed?
I'm currently a chef now. I'm working at the Lowe's Hotel.
Head chef?
I'm sous chef. I'm working on it. Eventually, I will be executive chef.
That's your goal, to be
Yes,
executive?
ma'am. That's
Good for
definitely
you.
long-term goals, executive chef.
How long you been at Lowe's?
I've been there a little over 6 years.
Oh, good. All right, any other questions?
Yeah, I'd like to ask a
Mr.
question.
Tillis has some questions.
Why do you need a gun?
Like I said, I really don't need a gun. I only apply for the party because it's the simple right of me just not, if I ever wanted a gun, I can't purchase it. But that don't necessarily mean I need a gun.
What would you purchase one for if you needed one?
Like if I want, I just want to be able to purchase one in the future if I wanted to.
All right, Mr. Sabatier, is there a statement you want to make to us before we vote?
I just want to say thank you guys for taking the time to even look at my case. Like I said, I've already took into the step as far as getting my record expunged, so I pretty much have a clean record already. And hopefully everything go in my favor.
All right, I think we're ready to vote, Mr. Freeman.
Okay, Mr. Sabatier, first off, I saw where your, I think it's your wife, your fiance had wrote that you did this all on your own, that you, initiated and everything, did it yourself. I want to say
Yep.
that you should be proud of yourself for initiating this. On the same hand, Mr. Sabatier, you say you smoked a year and a half ago, you went through drug court, you went through other things, and to be honest with you, you're still smoking, which gives me some concern. So my vote at this time, I think you need a cleansing period. I vote to deny.
Mr. Tillis?
My vote is to grant without firearm.
Ms. Stapleton?
My vote is to grant without firearm.
Mr. Prater?
I'd say grant with firearms.
All right, Mr. Sabatier, my vote would be to grant also pardon with restoration of firearms. However, you got the favorable recommendation, you got 4 favorable votes. We did not agree on the with or without firearms. That's a split vote.
Can somebody change their vote?
Mhm.
I'm okay with the firearm.
Okay, so you received 3 votes with the restoration of firearms, so that is the recommendation we'll make on your behalf. You
Okay.
understand?
Yes, ma'am. I got one question.
Listen, my vote is based on your work stability, the fact that it's a nonviolent offense, it was a low quantity, and your record has been expunged. Now, what's your question?
My question is, in order to actually get it approved, how many votes would I actually need?
4.
4, you got approved.
You got approved.
Thank
It was
guys.
issued, the pardon was, we agreed on that. The issue was with or without the restoration of your firearms rights. That was the question. But you got it.
And
Good luck.
Thank you.
you do understand that this is just the recommendation that we're
Cool.
sending to the governor. So
Right.
you can't leave from here saying you're pardoned,
Right.
okay? Okay, I just wanted to make sure you understood because some people might not understand that.
Yeah, you
No,
gotta
I
wait. If we make the recommendation, the governor has no specific time frame within which he has to act, but your next correspondence should be from their office.
Okay, thank you guys.
But
They gave it to me, Dad.
I got to tell you, I love the result of this one. And we're going to watch a small YouTube clip of Mr. Brandon in a second. But why do I love it? Well, I think it showed us a lot about the parole board members. It showed sheriff. Remember, he was a sheriff. And we just saw him, they did not allow the restoration of firearm rights. But that was to man who seemed that he would be a risk. And here was this case where the sheriff didn't hold oh wow, you like Mr. Friedman, well, you smoked like a year and a half ago, so I don't, like compared to Connecticut, where in Connecticut you have marijuana being given to you while you're like still in a halfway house on probation because it's called a medical card. And in Louisiana, it's like, well, I think 2 years ago you claimed that you smoked, so I'm not going to give it to you. But I like that. I like that you can see where how the sheriff feels about the Second Amendment rights, how Mr. Nasa feels about the Second Amendment rights, and then how Miss Stapleton went and changed her vote. I believe what I saw from Brandon. I think he wasn't articulate in the way of describing it, but he wasn't manipulative either. Wasn't making up the story. Well, I want to go hunting, which we see in a lot of these cases. People say it, but you don't get the feeling they really do. They're just saying, he's like, I want the ability to do it. And, I think someone who's more articulate might have expressed it a little differently, which is, I just want to have my Second Amendment rights if I wanted to. I don't plan on getting a gun, but I want to have those rights. And that's what I heard when I heard him describing why he wanted it. And he had just one thing on his record, possession of a couple grams, please. And they actually had the audacity to charge him with intent to distribute, which is a whole different discussion here. But I really like the outcome, and I like the insight that we gained from the poor board members. Now let's go take a visit. It's a 90-second YouTube video, courtesy of Richard finding it, of Brandon doing some of his chefery, and we get to see some of the Louisiana classic dishes in this little clip. So let's go take a dive into Louisiana.
If it wasn't for my son, I probably wouldn't even be doing what I'm doing right now. He motivated me to just want to change and do something different. I was doing the same thing, getting the same result. I realized in order to get a different result, you have to do different things. And my son motivated me to want to do that. I'm Brandon Sabatier. I'm lead cook at the Maison Dupree Hotel. I actually began working in food service when I was 18 years old. Fresh out of high school, I went to Cafe Reconcile and I was introduced to the food world. I just love cooking in general. Right from day one, I knew that this is what I'm supposed to do. But me and Mr. Ray kind of just had a bond right from the beginning. And I just asked him, like, if I cut my hair, would you give me an opportunity? And just from there, we just been working together. Tourism is a big part of the city, and it's a way of making money, and it's how we bring in revenue. Without tourism, I don't think the French Quarter would be what it is. I probably wouldn't even have a job. New Orleans will always be home. Tourism is how.
What's not to love about this? I think it's great, and I hope that we continue to see him grow and thrive and be successful. And I hope that this was just another step in that direction. And let's jump in to the next hearing.
Mr. Ballard, in your appeal of your conviction, it seems that you assert the kick was not intentional, that maybe you slipped.
Yes,
Or something like that.
I did kick him, and I did lose my step, or whatever. However, the kick was still landed, and I am very sorry for that kick.
We are about to watch a pardon hearing for a man who served 25 years in the force without any type of disciplinary action. He also served 30 years in the Air Force with distinction, but after coming out of retirement in his 60s, he received a felony for, they claim, kicking a man while he was in handcuffs. Now he is seeking to get a pardon with the restoration of firearms. Let's watch, and I'll unpack it with all the details at the end.
Yes, I did.
Is that okay? Okay, so we're going to get started. Mr. Van C. Ballard, your DOC number 771511. You're here today seeking a pardon with restoration of firearms. You were sentenced in Orleans Parish, May 31st, 2017, for a malfeasance in office conviction. You received a 2 years DOC sentence that was suspended. You were placed on 2 years inactive probation. Is that information correct?
That's correct.
And would you answer any questions Mr. Tillis may have?
Good morning. How you doing, Mr. Ballard?
Good morning.
I read through your record and I wanted to hear your side of the story of what happened.
On November the 3rd, 2016, I was working as an Orleans Parish Sheriff's Officer, working a paid detail in the Hurtsville area in the Upper St. Charles area. About 12:30 or so, I received a call from the 5600 block of Britannia saying that there were 4 black males in their driveway pulling on car door handles, trying to gain access to their vehicle. They also said that they were in the neighbor's driveway also trying to gain access. After taking that information, I drove to the area, started looking for the subjects. And while in the 900 block of Joseph Street, I could hear an officer shouting loud verbal orders for a subject to come out and show his hands. Knowing that that officer probably needed assistance, I ran down the alley, through the gate, down the alleyway. And as I was approaching down the alleyway, I had my flashlight. I could see 2 officers had a subject down trying to get the handcuffs on him. As I got to the subject who was still resisting, they still had not gotten the handcuffs on him, I kicked the subject. The blow landed in the area of his forehead and his hair. After that, we were able to get the handcuffs. The white officer was able to get the handcuffs on the subject. At that time, I heard a second noise coming from the dark area at the rear of the yard. I walked over the subject who was handcuffed on the ground. I went to the rear of the yard. I could hear the movement on the roof of the shed. So I climbed up on the roof where I was able to apprehend a second subject. I was able to handcuff him, search him, and waited for the assistance from the other officers who was on the ground. Officer Terrence Wilson came. I picked the guy up. I lowered him down from the roof to the custody of Sergeant Wilson. At which time I climbed down and I came out to the front. That's when I was advised by Lieutenant Kendrick Allen that Sergeant Wilson had made a use of force complaint toward me for kicking the subject. And it started from there. On the next day, which was the 4th, I received instructions via phone to meet Sergeant Terrence Wilson at a location off of Newton Street, where I was issued a summons for battery on the subject that I kicked. I went to municipal court several times, and I thought it was dismissed, but then I received someone knocked on the door and gave me a subpoena that I had to come to criminal district court. To the best of my knowledge on that part.
You know, as I read the report of the other officer, they had him cuffed and he was down. They had him cuffed, face down, with cuffs on him. And they said that you came up and kicked him. But you're saying he was struggling, trying to.
I was struggling. I ran down the alleyway, and it didn't seem that he had, because I stayed there for a minute till the white officer got the cuffs on him. I did kick him, and then I stepped over him and went on with the noise that was in the back of in the yard.
Not a standard policy to kick someone when they're down, is it?
If someone is resisting, sir, yeah, you can. I shouldn't have kicked him, but I did, sir, and I'm very sorry for that.
You're saying you can do that if he's down and resist?
No, I didn't say if someone's resisting, then you rather than lose your life, yes, you can do whatever means you can. There's certain areas that you can kick them in. A kick is legal, but he was not handcuffed yet. He was still trying to handcuff the guy.
I see. I have no more questions.
I have a question.
Mr. Green?
Okay, did you ever receive post training? Are you
Yeah.
post certified?
Yes, I am.
Okay, I am too. I've never seen where they told us we can kick anybody in the head.
That's true. That's correct. That was, I didn't intend
There's
to.
pressure points we aim at and different
Correct.
things like that. And I understand it was in the heat of the moment. But that was your intentions to help subdue the subject, correct?
That's correct.
Thank you.
Any questions?
Yes, sir. So you were issued a summons for simple battery,
Yeah,
correct?
yes,
And then
correct.
I assume the DA took it to the grand jury or something and or somehow got you indicted or charged with a more serious crime and took you to district court, correct?
That's correct. I think it was explained to me that they found the law because I was in the uniform, that it was malfeasance. But I was issued a simple battery summons, but I'm not sure how that happened, if whoever picked it up, but it was stepped up to where I had to go to criminal district court.
Okay. All right. That, I don't have any.
Okay.
I don't have any questions.
Mr. Ballard, in your appeal of your conviction, it seems that you assert the kick was not intentional, that maybe you slipped.
Yes,
and or something like that.
I did kick him, and I did lose my step or whatever. However, the kick was still landed, and I am very sorry for that kick. So
In the statements by Sergeant Wilson, he said that it was a field goal style kick and it was 100% intentional and unjustified. And then later on, he says it was dead in the mouth in an unwarranted situation. But then it was questioned of him, was EMS called to the scene?
correct.
And he could remember that. So with a dead on kick to the mouth like that, was EMS called or was
EMS
there other treatment needed?
EMS was called. They checked him. There was no bruises, no sign of blood, no injuries, no broken nose. And had I tried to field goal kick him, it would be a lot of injury. I did not intentionally kick him like that. As a matter of fact, it was my kick, I think, which assisted him calming down, and they were able to get the handcuffs on him. But I did not field goal kick him where there was blood, busted lip, or mouth, or teeth knocked out. That is not true.
Okay. So no medical attention when they got there was needed.
No medical's attention. Also, when he was brought to lockup, he was accepted at lockup. Had he had any injuries, face, eyes, anything, lockup would have taken him down.
Okay, that's what I needed to know. Thank you, sir.
All right, thank you. Mr. Riley, we'd like to hear from you, sir.
I'll try to keep it very brief. This has been a long application due to COVID, and I've had an opportunity to really get to know Mr. Ballard personally over the course of this time. And besides his exemplary record, military record, his 20-something years service as a policeman, which he retired from, and that's how he was doing the detail duty for the sheriff's department, because he had retired from the New Orleans Police Department, and he had been an instructor in firearms throughout his career. I believe certainly he understands the significance of what happened, and in fact, there's nothing else in this man. Judge Ziblitz, when he sentenced him, asked the question, do we take this man's exemplary life away for one episode of what might have been an overreaction in the course of an arrest? And I think his sentence is evidence of how he really felt that while something happened, that Mr. Ballard was probably guilty of some act in the process of the arrest. He gave him the 2 years without supervision and probation. Mr. Ballard has been a model citizen until then and after then. He has served this country, he has served our city, and I really feel grace upon him for this one indiscretion that we find in his record. He's been a father, and he raised his son on his own. He's led an exemplary life, but for this dot, and I can only say, just as I've heard others say, you put a dot on a piece of paper, yeah, you can see the dot, but there's a whole lot of white around that dot. And I think that Mr. Ballard, if allowed this opportunity for forgiveness and grace, will not let the board down.
Thank you, sir. Mr. Ballard, is there anything you'd like to say?
No, I just would appreciate your concern and your consideration for a pardon.
Can you tell us the reason why you're asking for a pardon?
I'm asking for a pardon for one. I was a firearms instructor. But when I retired, it was my intention to become the state police wildlife and fisheries. I can probably still get a job as an instructor. Also, I have some land out in the city, 19 acres of land that I own out in Mississippi. I've put a trailer. I put a 25-foot pole with a power head. I put 1,000-gallon septic tank in. I bush hog. I bought a tractor. I built a barn, and I hunt. I have a lifetime hunting license. I would like to still be able to hunt, and possibly if I could land a job as an instructor somewhere, get the job.
Thank you, sir. All right, I think are we prepared to vote? Mr. Tillis?
My vote is to deny.
Ms. Stapleton?
Mine is to grant with restoration firearms.
Mr. Prater?
Grant with restoration.
Mr. Freeman?
Grant with restoration.
All right, Mr. Ballard, I do agree. Pardon with restoration of firearms. I've heard what your attorney said and the judge's sentiments during sentencing speaks to me. So today you've received 4 votes to grant the pardon with restoration of firearms. So that is the recommendation we'll make on your behalf to Governor Lane. Good luck.
Thank you, board. Thank you.
Okay, let's unpack this. And we're going to unpack this by going over his appeal, which he lost after he had a bench trial for this. Now, again, I think to reiterate that he had served 25 years in the police force without any negative reports, plus the 30 years he had serving with distinction in Vietnam and the Gulf War in the Air Force. And then he has this one incident, which, you know, I think there's 2 ways, I guess, to look at this. There's one is, was he actually guilty? And then there's 2 was, if he was guilty, what exactly was he guilty of? And was the response proportionate? I guess there's 3, which is, hey, he was found guilty by a judge. A judge found him guilty. And was it severe enough for him to get this punishment, and should he get a pardon? So I guess there's 3 ways to look at it. Man, I'll tell you, from reading, which we'll go over now, the appeal, I personally didn't think that there was enough evidence to convict without a reasonable doubt. That's just me. And I don't know. It's really interesting. But anyways, let's just go over it, and then we can come to our own conclusion. On February 8, 2017, okay, so this is the procedural factual background where he filed the appeal. So at trial, NOPD Sergeant Terrence Wilson, which is the man who really made sure that this all happened by reporting, he's the one who said that he kicked the one being arrested in the face. He testified that he participated in the arrest of Maurice Johnson, the victim, on November 3rd, 2016, who, along with another assailant, was suspected of burglarizing vehicles. In pursuit of the suspect, the officers responded to the incident, locating the victim hiding under a house in the area, and were attempting to take him into custody. While the officers were apprehending him, Ballard, who was not assigned to the arresting officer's unit, showed up out of nowhere. This is who we just saw coming for the appeal. Now, Sergeant Wilson testified that neither he nor his colleagues had requested Ballard's assistance. Sergeant Wilson testified that he and Jorgensen coaxed the victim out from under the house and restrained him face down on the ground in a small alleyway while they placed him in handcuffs. In the process of making the arrest, Sergeant Wilson witnessed Ballard run up the alley toward them and heard, not saw, heard the thud of Ballard striking the victim in the mouth with his foot. Sergeant Wilson told Ballard that NOPD officers did not behave that way anymore and asked him to back away from the scene. So this statement right here ends up being the statement that leads to the conviction. The sergeant hears the thud in the face and says, and this is caught on body camera, not the kick. They don't catch the kick on body camera, but they just hear the voice of him saying, "We don't behave that way anymore." Sergeant Wilson testified that the victim had not made any threatening motions toward Ballard or anyone else. Sergeant Wilson stated that the victim immediately complained that Ballard had kicked him in the mouth and asked if the officers were going to do anything about it. Sergeant Wilson replied that he would handle it. Sergeant Wilson and Officer Jorgensen proceeded to arrest the victim as Ballard continued in the direction of the second suspect and assisted in his apprehension. So now Ballard ran off to get the second guy. Sergeant Wilson characterized the physical contact between Ballard and the victim as battery and reported it as such to Lieutenant Kendrick Allen. Sergeant Wilson testified that he and Officer Jorgensen had the victim in custody by the time Ballard made contact with him, and stated, once a person stops resisting of any kind of action stops, and we just don't receive that kind of training to kick people in the face. And again, keep in mind, this is not the victim filing the complaint. This is his fellow officer, which is a good thing. But again, I bring to the question, was there enough to even know if it was a kick or if it's accidental? On cross-examination, defense counsel asked Sergeant Wilson if the kick was accidental or intentional, and Wilson responded that he did not know why Ballard did it, although he admitted he did not ask. Notwithstanding Sergeant Wilson's admission that both he and Officer Jorgensen were yelling at the victim to show them his hands. Sergeant Wilson confirmed that the victim had already complied with their commands by the time Ballard approached, and Officer Jorgensen, I know I'm not pronouncing that right, was in the process of securing the handcuffs behind the victim's back. So he's in the process. He's not handcuffed yet. Sergeant Wilson described the alleyway in which the victim was apprehended as really dark and a tight squeeze. Overall, there were four fleeing suspects who were allegedly to have been burglarizing vehicles, climbing over people's fences, and onto their roofs in an uptown neighborhood at 1 a.m. Under these circumstances, Sergeant Wilson absolutely believed the suspects were dangerous and that it was possible for someone in Ballard's position to believe that they were capable of resisting arrest. Now, the body camera footage. Counsel for Ballard played the body camera video again in open court, and Sergeant Wilson explained that the clicking noise heard in the video indicated the handcuffs were being secured and the thud of Ballard kicking the victim occurred afterward. Following Ballard's contact with the victim, Sergeant Wilson looked up. Now they say that it was played in open. I would love to FOIA this. Someone FOIA it for me. Saw Ballard and told him that was not how they operated. This was heard in the body cam. That's not how they operated, which was audible in the body camera video. In Sergeant Wilson's haste to secure the fleeing suspects, he did not have time to extract Ballard from the scene. Following the arrest, Sergeant Wilson could not recall whether the victim had sustained any visible injuries, but he believed EMS had been called to the scene. Sergeant Wilson also contacted the OPSO and reported the Ballard's contact with the victim. At some point later in the day, Sergeant Wilson gave an official statement to NOPD Sergeant Barnes in which he characterized Ballard's actions as a field goal style kick. And this is again where I think there's some conflicting thing, because anyways, let's continue. And that he had no doubt that it was 100% intentional and unjustified. As reflected on the body camera video footage, Sergeant Wilson also made a statement to OPSO Lieutenant Morrell that the scene shortly after the incident, in which he stated that it was conceivable that something other than an intentional kick had occurred. On redirect, now remember, they're in trial, right? They're in court, a bench trial. Redirect examination, the state again played portions of the body camera video in court, and Sergeant Wilson agreed that he told his direct supervisor that Ballard kicked the victim dead in the mouth, and that it was unwarranted in that situation. Sergeant Wilson explained that he was more comfortable speaking to a supervisor than the investigator from the OPSO, whom he had never met before. So he was reluctant to give his full impression to the OPSO investigator. However, Sergeant Wilson testified that at no point did he believe that Ballard's boot struck the victim's face by accident or coincidence. Sergeant Wilson did not recall Ballard making any statement. Sergeant Wilson prefaced this testimony with an explanation that the court, that which he explained that it can be touchy for police officers to give statements to other police officers about complaints regarding the actions of police officers. He further explained that the statements he made to Lieutenant Morrell at the scene was the way he felt at the time, amidst a chaotic backdrop of the arrest and pending internal investigation. To him, during or after the incident, indicating that the contact was accidental, and repeated that he did not ask for, nor did he believe that Ballard's assistance in apprehending the victim. So he's saying, like, we didn't even want him there. NOPD Public Integrity Bureau Sergeant David Barnes testified that he investigated the alleged battery of the victim 8 hours after it occurred, interviewed the officers who had been there at the scene, and reviewed the body camera footage. At the time, the scope of his employment included investigating use of force and serious use of force complaints implicating possible criminal liability. Although Sergeant Barnes did not interview Ballard, he investigated led to Ballard's arrest for simple battery. At the time of the incident, Ballard had been wearing an OPSO uniform, and Sergeant Barnes learned Ballard was commissioned reservist with the OPSO, was employed as a civilian, and held a retired commission at the NOPD. On cross-examination, Sergeant Barnes explained that a civilian employee of the NOPD Ballard did not possess the authority of a sworn officer, although he could not speculate about the authority Ballard may have had with an OPSO. By the time Sergeant Barnes joined the investigation, Sergeant Wilson had already issued Ballard a summons for municipal battery. So the same sergeant that said, we don't do this anymore, wrote the ticket. Not an investigating sergeant, not someone else. The guy used to be, and this is again where I start to have a problem with this, because we just don't know. Like, to me, it seems to come down to two people, Sergeant Wilson and Mr. Ballard. He also testified that at one point, the body camera footage he reviewed showed the victim resisting arrest and admitting that he cannot hear the thud of Ballard allegedly kicking the victim in the face. The crime of simple battery. The court had heard previous testimony that Sergeant Barnes at the preliminary hearing and requested not to be. Following Sergeant Barnes' testimony, the state offered and Ballard accepted a stipulation that Ballard was a reserve commissioned law enforcement officer with the St. Louis Parish at the time of the offense. Ballard testified in his defense, so he takes the stand. He indicates that he received a call from the resident neighborhood he was patrolling. So he's patrolling it. He's not like driving by. He's in uniform. He's patrolling it, reporting that 4 suspicious-looking individuals were pulling the door handles on cars in the neighborhood. As he arrived at the scene, he encountered numerous NOPD officers searching the area. Ballard stated that he heard yelling coming from the alleyway. He believed that the police officers needed assistance. As he ran down the dark alley towards two officers he had suspected the ground, his knees gave out, causing him to pitch forward, inadvertently kicking the suspect in the mouth. Remember, he's in his 60s. He's out of retirement. This, not so long ago, or even under different circumstances, a newspaper would have picked this up and called him a hero. They would have said, retired war veteran, retired police officer comes back on the force, helps the fellow police officers apprehend. Remember, there are 5 suspects. They're all over the place. They only knew where one was. He helps arrest one. He jumps up and helps arrest another, and he would have gotten, a key to the city. And in this situation, the fellow arresting officer, and again, maybe he did the right thing. I don't know. But he actually gets a ticket, and then he gets a felony. Ballard testified that Sergeant Wilson, who was in the process of handcuffing the suspect, looked up at him and told him, "We don't do that anymore." According to Ballard, rather than stop and explain the kick was accidental, he proceeded to the backyard of the house, apprehended another suspect. He goes and arrests another suspect. This is important to read. Ballard had been patrolling the area. He was not fully restrained and was lightly resisting. At the time, Ballard kicked him in the face. During Sergeant Burns' investigation, Sergeant Wilson had described the field goal style kick, but also claimed that there had been no reportable use of force used by anybody during the arrest, although Sergeant Barnes explained that meant there had been no complaints of injury. Remember, the guy who was kicked didn't even want medical treatment. And this guy, if only he knew the victim, only he knew, if he had just asked for medical treatment, this would have been a payday for him. Wow, talk about missed opportunity. Based on his investigations, Sergeant Barnes concluded that the physical contact between Ballard and the victim did not appear unintentional. The court accepted the stipulation to avoid. Look, police have got to police, and we can't have police running around kicking people in the face. But I also wouldn't want this guy to be my wingman if I was in the police force. I'll tell you that. It just seems. Although Ballard assigns 7 errors of review, malfeasance in office standard review sufficient evidence. It just feels like a witch hunt. Because I don't see the proof. I don't see it. Let's see. Contrary to Ballard's testimony during the course of investigation, Sergeant Wilson testified that Ballard's kick was a field goal style kick, which was 100% intentional and unjustified. In evaluating the evidence, the trial court indicated on multiple occasions that it did not believe Ballard accidentally slipped when his knee gave out, and noted that immediately after the incident, Ballard was able to run into the backyard and climb a ladder to apprehend another suspect. Considering the observation by the trial court, I just agree. You could still slip and fall and be able to run up a ladder. This is not contrary to the idea that you could have slipped. It's just not. Considering the observation by the trial court, coupled with Sergeant Wilson's testimony that the kick was a field goal style kick, which he believed to be intentional, we cannot say the trial court erred in its conclusion. We found that there was sufficient evidence. No, I don't buy it. Now, is it possible he intentionally kicked him? Yeah. Is it possible he lied that he didn't intentionally kick him? Yeah. He could have. Remember, it's dark. There's 5 people running around. It was a small alleyway. Maybe he thought they were having struggle handcuffing him, and he kicked them in the face. That's possible. But is there beyond a reasonable doubt that he didn't run there and trip and kick? No, not in my opinion. I don't know. The whole thing, I'm happy he got approved, but the whole thing does bother me. Anyways, love to hear your thoughts. Thank you, Richard, for the info. And with that, I'll let you.
Did you ever cut Raven Broussard? Did you cut some fingers off of him?
No, I'm sorry, no.
Okay, sure.
I'm positive. Raven and I, back in the day, we used to fight a lot because he was constantly cheating, but I've never cut any of his fingers off. Never.
Probably not a question you want to be asked when you're trying to get your record expunged. We are about to watch a pardon hearing out of the state of Louisiana. Let's jump in.
So, Shavonda Williams, your DOC number is 403972. You're here this morning seeking a pardon with restoration of firearms. You were sentenced in the 15th Judicial District in Lafayette. And let's see, you were sentenced in October 1998 for an aggravated battery conviction. You received a 3-year sentence that was suspended, and you were placed on 4 years of probation. Is that correct?
That's correct.
Would you answer Mr. Freeman's questions, please?
Okay, Ms. Williams, what was going on that night between you and Marissa? I mean, what was the problem? And tell me the truth, what started it off?
So Marissa and the father of my 2 girls, I was pregnant at the time of the incident. They were having a secret relationship, and she had been calling my job, trying to get me fired. She had been calling my house. And the night of the incident, her mom and her brothers were at my boyfriend at the time, his basketball game. And her mom brought them over there. And after the basketball game was over, I was across with the guys who just finished playing basketball. And Marissa and her 2 brothers came running up and cursing me, and we got in a fight. They tried to jump me, and the guys from the basketball team, they kind of helped out to try to get them to leave me alone. And I was working at the time at this company where we had to rip bags. So I had a box cutter at the time in my pocket from work. And when they all came to attack me, I pulled it out and I swung it, and it hit her on the side of her face.
Okay. So, are you and Marissa kin?
We are not related at all by Williams. However, Marissa's uncle is married to my aunt. So we've known each other since we were children.
All right. And your boyfriend, that's Raven?
Raven Broussard, yes.
Okay. Are you still together with Raven?
No, we haven't been together in over 20 years.
Okay. All right. Do you have your children? I know they're grown now, huh?
I have a son after that situation. He's 19, and I have 5 grandsons.
What are you currently doing for employment?
Regional property manager for involved communities. I've been working in low-income housing for the last 20 years.
All right. Did you ever cut Raven Broussard? Did you cut some fingers off of him?
No, I'm sorry, no.
Okay, sure.
I'm positive. Raven and I, back in the day, we used to fight a lot because he was constantly cheating, but I've never cut any of his fingers off, never.
The DA and the chief are closed, your family's not, a victim had no comment. Why do you say you need this pardon? In 2008, you needed it to get your nurse's license. Why do you need it now?
So I'm trying to further my career. I want to go for a VP position. And I would really like for my record to be clear when I do apply for this position. I've been a regional manager for 10 years in low-income housing. I've worked at the public housing in Lafayette, the same projects my mom raised us in. I became the public housing director over that years later. I am trying to get a VP position. And like I said, I just want to make sure that my record is clear. Since I've been in low-income housing, I've done a lot for the communities. I've even started a GED program for the city of Lafayette. And I was picking up the residents at the time when I was employed there so that they can get their GED. I've also been working with ARCH, which is the Coalition for Homelessness in Lafayette, to help those people get housing as well. My record for performance has been impeccable in my field, and I just want to further my career and make sure that when I do step into this next role that I'm trying to step into, that my record is clear and I can also reach out to more people who's been through the same things that I've been through and who have changed their lives as well.
Great. All right, and you did receive a pardon back in 2009, is that correct? And it
Correct.
just was signed as Governor Jindal?
Yes, Bobby Jindal was.
So apply for one during Governor Edwards' administration?
That's correct.
Did you? Okay, what happened?
No, I'm sorry. And when Bobby Jindal was the governor, I came down to Baton Rouge. I brought witnesses with me. We went through the entire thing. The pardon was granted. I received a letter in the mail saying that it was granted. But when I found out later that it wasn't signed by him. So I contacted an attorney's office. I contacted the pardon board, and I was told by one of the young ladies there that I would have to go through the process again because he didn't sign it.
Okay, and this is your first time back or not?
First time back.
Okay, I have no further question.
All right, any other questions?
Yeah,
Mr. Phillips?
you said you wanted a pardon with, to have a gun also?
I'm sorry.
You also wanted to have a gun, permit to have a gun or be able to carry a gun? Or you just wanted a pardon?
No, actually at the time that's how I found out I wasn't pardoned. When I went to go, because I was going to do these gun classes, I was signing up in different states. I have a brother who is ex-military, and he wanted to do these gun classes, and we wanted to get licensed in every state. We were going to go into business together. To do this, I was kind of going to be the funding behind his program, and that's when I found out that I wasn't pardoned.
Do you think you need a gun?
No, definitely I do not need a gun, but I was going to do those classes with him and travel with him. I'm also, I have other businesses that I've started. I'm also a box truck business owner for Amazon. I've been doing that as well for almost 3 years, and I was going to help him out on his business side and do that with him.
So you won't need a gun?
No.
Okay, that's all.
Okay, any other questions? Ms. Williams, is there are no other participants, so is there anything you'd like to say to us before we vote?
Yes. It's been over 20 years. I've not been in any trouble since then. I've been, that was kind of an isolated situation. I was very young. I lacked a lot of guidance at the time. And I understand that what I did was wrong. I should have removed myself from that situation a long time ago when all of the drama started with Marissa, when she started calling my job and all of these things, trying to get me fired. I should have separated myself from the situation, but I didn't. And I apologize for my actions in that situation. And I'm just asking you all to have some mercy on my situation and grant my pardon if you can. And I respect you all, and I thank you for taking this time to see me today.
Thank you, ma'am. I think we are prepared to vote.
I'd like to move for an executive session.
We have a motion for executive session. Could we get a roll call, please?
Renato?
Yes.
Yes.
Here. Yeah.
Here,
Yes.
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 Okay. Ms. Williams, we'll be in executive session for a few moments to discuss confidential matters. Stand by. We'll be right back.
Yes, ma'am.
Williams, we're back in session. It's 10:52. We are prepared to vote. Mr. Freeman will be voting first. Mr. Freeman.
Okay, Ms. Williams, you do have a long cleansing period, over 20 years. It was a violent crime. Also, I messed up, and I'll admit it on record. I did not see the second victim statement, and the victim is strongly opposed to this granting, so my vote is to deny.
Mr. Tillis.
My vote's to grant
With-
without
bounds.
grant without file.
Ms. Stapleton.
My vote is to deny due to, the crime was very violent and it took place at a basketball game. Although you have done extremely well since then, and that's commendable, but your victim is very opposed.
Mr. Prater.
I vote to deny.
Ms. Williams, you've received 3 votes to deny your application. I will concur based on the opposition that we've gotten from the victim and others. You have one favorable vote, though, but 4 votes to deny your application for clemency has been denied.
Can I ask a question?
Go ahead, ma'am. What was the question?
I've not had any contact with the victim. Her brother actually called me and told me
Well,
that
it's irrelevant at this point. We have what we have in the record, so we're going to go with what we got. I'm sorry.
I was surprised that they came back. Good for them. I'm happy that they came back and answered the question. Although, it was interesting that there were 2 victims. And at first, Mr. Friedman said the victims were unopposed, but that was the boyfriend that maybe got his fingers bitten off that this case isn't even involved with. And then you have the second victim who is very opposed. Maybe she has a scar on her face. Maybe. Now, I just want to tell you, I don't know if you have seen the Connecticut pardon hearings, but the contrast, the difference could not be more significant. We see in Connecticut where they just hand them out like candy. And also another big difference is that the board in Connecticut has the power to grant the commutation. Unlike in Louisiana, all the board does is recommend it to the governor, which is what we saw in this case. She was recommended in 2008 and the governor never signed it. Now, why the governor never signed it, we don't know it. I believe it could be for a simple reason is that the paper ended up on his desk and he kind of forgot about it. I know that's just but it's not the first time we've seen it happen, not just for pardon hearings, but also commutation hearings. And, frankly, I like the Louisiana process much, much more because it holds the governor accountable. For one, if I, for some reason, became a governor of any state, the first thing I would do to protect myself would be like, I'm going to give the board the power to grant. And why? Because you can't be held responsible when someone is granted a pardon and then they go out and commit a crime and then the newspapers go crazy and say the governor signed it. And that's what Connecticut did. Connecticut, some governor, I don't know when, but maybe it was always part of their constitution, but in Connecticut, it's the board that will take the fall for the boss, the governor. And in Louisiana, the governor is the one that has to ultimately sign. And we see recommendations that are not signed. Now, in this particular case, this would have been handed down in Connecticut like this. I mean, it's been since 1998. She is a successful person at the same job as a real estate manager by all accounts that I've seen. And you might argue that, yeah, she should get a pardon. She should be able to move on. But the problems that I have with this is that it seemed like a lack of accountability. Well, she came up to me. There was this. I had a box cutter and I slashed her face. And we don't have details to go into unpacking on this case, but it sounds like it was probably pretty scary. And then you throw in that wrench where it seems like with her boyfriend cutting or biting his fingers off. And then you start to wonder if there's something deeper here. And the way that she kind of laughed it off was a little bit like, you're kind of looking for some sense of honesty in these situations. Although we don't have any of the information, I think what she really could have used is an attorney and to take accountability. And man, I mean, if you're pregnant and your man's cheating on you, like you got all your hormones going and you just happen to have the box cutter, these things, it might happen, but I guess you just want to take accountability for it. And maybe they were concerned about that, but still in Connecticut, they would have granted, I think, in a drop of a hat. What do you feel? Even with the lack of accountability, I think that her long track record of success and the idea that the felony is really only holding her back, she wasn't asking for a firearm. I'm for granting, frankly. This isn't about getting paroled. This is just about helping her excel in her career. But you tell me. Anyways, with that, I'll let you go.
Okay, next we have Jermaine McLean, represented by Attorney Gelino.
Thank you, Madam Chair. Thank you, members of the board. Christopher Gelino on behalf of Mr. McLean, who is sitting to my right. I'd like to make a brief introduction, but before I do so, I'd just like to report that there are no changes to my client's conviction history, no new arrests since the application was filed. By way of introduction, Mr. McLean's personal statement in particular describes a youth that was filled with some bad influences and some bad choices that were made by a person who was still searching for direction. Though he only has one conviction, the charges in that case are very serious. There's certainly no doubt about that. But Mr. McLean takes ownership of that conviction and has spent the last decade working to prove that he is not the person that his record says he is. He's remained crime-free during this time and has found a better direction in his life. He started a career in the trucking industry and is looking to advance his skills and responsibilities further if he is given a pardon. In his free time, he works with his father on some odd jobs around the house and spends a great deal of time with his girlfriend, his sister, and his nephew. He does not own a gun, does not plan to in the future. In short, he is now a man who is accountable, stable, and motivated. And I'd like to turn it over to Mr. McLean now to address the board himself.
Okay, please state your name for the record, sir.
Jermaine McLean.
Thank you. At this time, you may explain to the board why you believe you are suitable for an absolute pardon.
I made a few mistake a couple years back that I regret very much. I'm still paying for it. I'm still making up for my past wrong that I've done, and I've been trying to do everything in my part to rid myself of that wrong. I've been trying to stay on the right path, been doing the right thing, been staying away from trouble, keep myself out of trouble. I don't hang with people that I used to hang with no more. Did a whole U-turn with my life, just trying to be a better person for society, because that wasn't really my life, stuff that I was caught up in, and that's not the life that I want to live, and I will never go back down that path. So I've just been working on bettering myself to be a better person for society and doing the right thing, keep myself out of trouble, and just keep being on the right path.
Thank you, Mr. McLean. Appreciate that opening statement. I'm going to turn it over to Mr. Rodriguez.
Thank you, Madam Chair. Mr. McLean, is that, as your lawyer even said, this was a very serious offense, and I'll be quite honest, in reading the information that I read, I mean, I wasn't sure exactly what was going on. There were, statements that, in fact, there was you shooting back and forth. And can you just share with me a little bit more information? I felt like there was a lot of, in the documents that I read, I felt there was a lot of minimization on your end around the offense and what happened.
Was like on a Sunday, 2013, I think, was an incident that happened on Adams Street off Albany Avenue, on Adams Street, where the shooting. There was a guy that was driving a black car, and
yeah, I know. I kind of read all that information. I'm just not clear on your. You said you made a mistake. I'm not clear on your responsibility in all of this. That's what I'm not clear of. Because we've read the whole incident and the whole, what happened, what occurred. But in reading it, I got kind of mixed messages and not really any clarity on what your responsibility was in this.
Shootout that ensued between me and a guy
So it was a shootout.
Yes.
Okay, so because that's not what I read in the documents. It was kind of minimized on your end, even though there seemed to be evidence that there was a shootout that had gone
witnesses.
on. Yeah, and witnesses, to boot. Were there issues with So anyway, so now you're sharing that in fact there was a shootout. Is that correct?
Yes.
Okay.
Yes.
Thanks for clarifying that, at least for, updating us on that. Issues around substance abuse. How long have you been clean?
Quite like 8, 9 years now.
And how do you maintain your sobriety and your cleanness, your clean time?
I spend a lot of time with my family. I go to the gym, workout, and I tend to work a lot, so I stay on the road. Well, I'm always traveling, so I stay away from all substance. I can't use any substance while operating a commercial vehicle, so that helps a lot also. And going to the gym, working out, that also helps a lot. It keeps me focused. And
So you're not doing anything around any recovery kinds of programs or anything?
no, not at the moment.
And is it something you've given thought to?
Yes, but I'm not using any substance at all. So, but it's something that I've given thought to.
Okay. How's your work going?
It's going great. I actually like it a lot. That's the whole reason why I'm trying to get this pardon also, so I could apply for my asthma endorsement, so I could go further in the trucking industry.
Yeah. And are you doing anything in the community?
Not at the moment.
So you're not doing any kind of volunteer work or any kind of work, helping out anybody or working with anybody or?
No, not at the moment.
Okay, well, I have to be honest with you. I'm concerned about the nature of the charges and the early minimization of all of this. And I'm glad that you shared what you shared today. And I think you're headed in a good direction. You've got 7 years, almost 7 years of not having been involved in any kind of crime or any arrest or anything. And that's very very positive. And I'm hoping that continues for you. But I am challenged by the nature of this offense and what's happened. There's a person who was in your car who ended up getting shot.
My girlfriend at that time, Candace Strickland.
Yeah. And I know she was hurt. I hope she's doing well and doing better.
Yeah, she's doing great.
Yeah. Are you
Mr.
still
Rodriguez, I'm
involved?
wondering if I also might be able to make a contribution to the conversation very briefly that I hope might provide a little bit of clarity for members of the board, if that's all right, just in terms of the application itself. With regards to the description of the charge and the explanation for what happened. So our office, when we assist clients with completing this application, in terms of the actual completion of it, that's my language that was being written. That was basically the way that it works is we sit down with our clients, we talk about what happened, we kind of go from start to finish, and then we do our best to distill that into something that's a couple sentences long, that's understandable and something that can be explain what's happened in a concise way. And in prepping for this hearing, I read through the description of the charges again, and I agree with you that I think in my efforts to distill Mr. McLean's explanation of what happened into something that was understandable for the members of the board, I think that I dropped the ball in being able to explain exactly what happened in the way that it needed to happen. I take accountability for that, and I would certainly never presume to tell the board how to make a decision, what to do, how to do your job, or anything like that. But if I may humbly just make a request of the board members that they take into account Mr. McLean's personal statement, his explanation today of what's happened, that more so than my explanation of the charges themselves reflects his understanding of how things happened and who he's become in the years since.
Well, I appreciate.
We do have the official record of the incident, and when in communication with the police, he denied firing back shots, said he didn't have a gun that day. So, Mr. McLean, why did you have a gun?
I have no idea, Ron. I don't know what I was thinking at the time, why I even had a gun to begin with.
Had you had it long?
Not really, no.
Okay. And did you take it to the range and practice how to handle and discharge it?
No.
Okay. So, we make decisions in light of the interest of public safety. And this is a big ask that you would choose to arm yourself with a gun you didn't know how to handle and then discharge that weapon out in the community, endangering a whole lot of people. And, I'm concerned that in your statement, you referred to it as a mistake. And I hope you appreciate, Mr. McLean, this was a choice that you made, multiple steps in this process that led to this conviction. You decided to acquire a firearm. You decided not to train with it. You decided not to get a pistol permit. And then you decided to actually shoot that gun from your car and engage in what you described as a shootout. So do you understand how concerning this is?
Yes.
Okay. And all of this, happened just 7 years ago, and you've been off supervision just 5 years.
Yes, it actually happened in 2013.
The conviction was 2017. Yeah. Okay, Ms. Chance, any questions?
I guess do you know who shot at your girlfriend, or did you accidentally shoot your girlfriend while you were firing those shots?
No, I did not accidentally shoot her. It was the other person that was shooting. Shot her.
And did they find out who shot your girlfriend?
Yes, but the guy was in court for some shooting incident. They had charged him for some shooting. I think they said I think it was he had shot somebody and they died. But I think they said they only gave him like 7 years.
Right, but they didn't get him for this charge because you weren't willing to tell them who shot at you.
Yeah.
Or who you were shooting at. Okay. You've gone on to earn your CDL. You've been a driver since 2022. You shared with us that you like doing so. You've been stable in your residence with family in Hartford. So there are some very positive signs of change. It's just an incredibly concerning set of circumstances that the totality of this conviction, especially with the ongoing problems with gun violence in our society. So, Mr. Rodriguez, where are you standing at this point?
Well, I'm challenged by this, Madam Chair, because there are some positive things that he's been able to do, but the nature of the offense, just for me right now, it's just a little bit too much. A shootout in the middle of the street, somebody got shot. It's only been 7 years. And then the whole issue of the minimization of the involvement of the offense early on, and I appreciate the attorney sharing what he shared with us. I really do. I'm not there today.
Okay. Ms. Chance, where are you? I'm willing to give Mr. McLean a shot.
So I guess that's,
oh my God. Okay.
That's kind of, where I am. I understand that sometimes people have issues with explaining or expressing themselves. But I can see that Mr. McLean has certainly worked on himself since this incident happened. And, he no longer, I believe he probably was drinking at one time, but he no longer does that. He says he's been clean and sober for 8 to 9 years. The fact that he got a CDL and is considering moving on at a higher level to get his hazmat license, I would be willing to grant Mr. McLean a pardon today, Madam Chair.
Okay.
And Madam Chair, I haven't heard the two of you,
You're certainly
I may just go ahead and go along with the majority.
Okay. So in the matter of Jermaine McLean, there is a motion to grant full and absolute pardon. Ms. Chance,
Aye.
Mr. Rodriguez,
Aye.
and the chair votes aye. The pardon is granted. Congratulations, Mr. McLean.
Good morning,
Thank you,
everyone.
Madam Chair.
I'm here for one case. What number are we on now?
This is perfect time. We can jump ahead to Mr. Rivera.
Thank you.
Thank you. Madam Chair, I was just going to ask for a break.
There you go.
Well, there you have it. I don't think the contrast could be any more vivid than, you know, Louisiana, and then there's Connecticut. It's like they take you through the journey where they're like, there's no way they're granting. There's no way. Then you get the first denial. And then all of a sudden, and I don't understand why, but Ms. Turner goes in and says, like, you know, I'll grant Miss Chance if you know. So she like hints to Miss Chance, and Miss Chance grants, and then he changes his mind. Have some conviction. You're on the board. What, you're really gonna change your mind like that because they're changing their mind? Now I get it. You know, Miss Stapleton just did that too, but it's a little, I don't know, a little different maybe. I can't. I just can't with this stuff. Think about this. He minimizes what he says in the application. His attorney falls on the sword for him, which is what the attorney should do, and give the attorney credit for doing that. I don't buy for a second that, you know, the attorney gave the information the guy gave him. Then another red flag, he says, oh, how long have you been sober? Oh, I've been sober in 8 to 9 years. There's an exception to every rule. But typically, the majority, from what I've seen, when you ask someone who's gone sober, they don't tell you 8 to 9 years. They tell you they're sober. They can tell you their sober date. They can tell you the last day they had a drink and what it was. It's not 8 to 9 years. And the idea that they're going with it is beyond me. Then you have that it's only been 7 years since his last crime, or since this crime. And I know there was some discrepancy that he mentioned, but I heard 7 years over and over and over. So I'm going with 7 years, and that's just, again, crazy. You're going to get a part. You just had a shootout in the street. Your girlfriend got injured. Then you find out that he never tells the police who it was that he's shooting, which, you know, you're thinking gang affiliation or something. That's what I'm thinking. And then they pardon. And it's just like, what? I mean, another thing, and we hear this all the time in the Connecticut hearings. It's really strange to me, but we hear it all the time. And that's whenever someone says that they had a gun illegally, they always say, did you go to the firing range with the gun? They're like, what? No. Did you ever learn how to shoot the gun? Well, no, because like it's a double-edged question, right? You don't want to. Well, then how can you be out in the street with a gun if you don't know how to use it? And they say that every time. I'm like, what? They're felons. They're using the gun to kill people, to have shootouts in public streets. Do you really want them to get trained so they can be more proficient with it? Now, I agree. People should get training to have a gun, but the point that this Connecticut board makes with it makes no sense to me. One is that there's like 30-something states that you can get a carry permit where they don't require you to train with the gun. I think that's a mistake. I think you should be required to train with the gun. I am a major advocate for the Second Amendment, but I also think that it's a very big problem that we don't have better, just for the safety aspect of it, just for the to get the familiarity with it. I mean, to have a gun and not have shot over 1,000 rounds in it just in practice, I think is a mistake. And that's at a minimum, you know. But anyways, but the idea that it's always brought up for the aspect of felons is something I just can't wrap my mind around with this Connecticut thing. It just makes so bizarre to me. But anyways, they grant him, and it's again, remember the governor doesn't have to sign off on it, so the governor doesn't care. And I believe that there is an initiative, an agenda in Connecticut to grant as many as possible. And what they have before these hearings, by the way, is they go through the a month before, they go through an application of all the applicants, and they read all the applicants, like a two sentence on each one. And the parole board grants, off of reading those two sentences, like 95% of the applicants without ever even having this interview. They only save this 5% interviews for the ones that they think they should have a talk with. So the pardons are being handed out like hotcakes without even interview requirements. We only see the worst of the worst. They do deny some outright, so almost all the worst of the worst. Some we don't see. And then they still grant. And it doesn't make sense because you can always say, just reapply. You know, you're doing okay, but just reapply. You know, a pardon is it's such an incredible thing. It should have more substance. Anyways, that's my soapbox for today. And I like that we can see the difference between Connecticut and Louisiana. And we'll do one more that has a twist. Let's go.
Justin Freeman with his client, Jose Bryan.
Good morning.
Good morning.
Attorney Justin Freeman on behalf of Mr. Jose Bryan, who is present to my right. I have the pleasure of representing Mr. Jose Bryan, as I indicated. To my knowledge, there are no updates or changes in his application. And my client and I would like to begin by thanking the board for this opportunity to address the panel. I would like the panel to realize that the last conviction in this matter, Mr. Byron's conviction, was roughly 15 years ago. I usually prefer to give a brief introductory statement, but this morning Mr. Byron brought in a prepared statement where he would like to address the panel. So I'd like to turn the stage over to him. I would also like to make a request that at the conclusion of your examination of Mr. Byron, that I have 2 minutes by way of rebuttal or to readdress the panel at the conclusion of his testimony.
At the conclusion of his testimony, not after the questioning.
After the questioning, please. I'm sorry. After the questioning.
Oh, we don't do
Okay.
rebuttals.
Okay. Fair enough. Thank you.
Mr. Byron?
Members of the pardon board, I want to start by expressing my deepest remorse for my past actions. I understand the harm I caused and take full responsibility for my poor choices in life. For causing my wife, Naira Martinez, emotional distress while going through a divorce process, who owes all the credit due of her upbringing and raising up my daughter. Over the past 29 years, I worked very hard to transform my life. I've completed counseling, education, rehabilitation. I've also had the opportunity to reflect on my values and goals, and I'm committed to continue living a positive, productive life. I understand that I cannot undo the harm that I've caused, but I assure you that I am dedicated to making amends and contributing to my community in a positive way. I have a solid support system. I have worked the past 29 years in corporate America. I've been able to purchase a home where my mother resides in today. I am grateful for this opportunity to speak with you today and demonstrate my growth. I'm eager to continue my journey and prove that I am capable of living a law-abiding life. One of the reasons I applied for this pardon is because I am seeking better employment through government contracts in the trucking field where I reside in Chicago. Unfortunately, my background has limited me to obtain these contracts. Furthermore, also becoming a United States citizen after 53 years in this country. As I progress to my retirement years, I strongly believe the United States has given me the best tools and the opportunity to become the best provider in present and past to my child, who went through hard work and dedication. Thank you for your consideration of my application, and I appreciate your time and attention. Thank you.
Thank you, sir. Anything to say, Mr. Freeman?
No. If you would please proceed. Thank you.
Okay. So I'll begin with the questions. you had 5 arrests between the years of 1987 and 2010. Your last arrest was family violence in nature. You violated a protective order and served 3 years of probation for that successfully. So you've been off supervision 11 years. And you've done a great deal to turn your life around. While you were on probation, did you complete a domestic violence program?
Absolutely. I did intense AA and NA. One of the things that my counselor at the Rockville Community Service, she sent me to a program where we were just females, which was very intriguing to me because I saw how domestic violence impacted women. Even though I lived through a domestic violence family, which my father was a horrible, horrible person to my mother. So I saw how it impacted women on the outside. And also I saw it, I lived it through the lens as a child growing up. So yes, I did an intense anger management.
I'm more interested in whether you completed a program for offenders, like the Explorer
Yes.
program.
Yes, AA, NA, yes.
No, I'm talking about a domestic violence program. They're
Yes.
specifically through CSSD, the Explorer program.
Yes, I did. The court mandated that.
Okay, so where did you complete that?
Rockville Center.
What agency ran the program?
I don't know. I don't recall, but I know it was in Rockville Center. I had to go through anger management there and domestic violence.
So you completed both anger management and domestic violence?
Yes,
What
anger
years?
management. Excuse me?
What years?
2011, and I think it was 4 years I continued the program through 2013, I believe. It was all in Rockville while I was on probation. It was all in Rockville, Connecticut.
Okay. So you had 3 of your convictions involving illegal substances. The 2 more recent, you were actually selling drugs, which does a tremendous amount of harm in the community. And in your application, there's nothing listed under employment and community activities that indicates any volunteer work. But in your opening statement, you claim that you do that. So what volunteer work is it that you do to give back to the community?
As soon as I got released in 1995, I did tremendous volunteer work because it impacted me while I was incarcerated from 92 to 95. It was 39 months. What I had done, I was extremely remorseful. I joined up with basically the government where I went to high schools and I explained to them the upbringing and the things that I encountered, what I did and what was the end result of my actions. So there was a lot of kids I spoke to during the high school through 95 through 2001 that I went and I basically did volunteer work. And I basically indicated, as a matter of fact, while being a manager at Best Buy, most of these kids would come from the outer schools into Best Buy and they will recognize me. Hey, are you the guy that you said? Yes, I am the guy that came to your school and spoke to you about the implications of narcotics.
Okay, so are you involved in any
Right now,
volunteer work or efforts?
in Chicago, yes, I am. The youth program. Basically our establishment where I work at, basically we do donations for volunteer youth workers in Chicago. It's, you know how the crime violence it is out there. Yes, I do.
What do you do at this youth program?
We volunteer. I don't volunteer time. It's more like monetary.
Okay. So you have a standing criminal protective order against you until the year 2099.
Yes, ma'am.
And do you have any contact with your daughter's mother?
Presently, no. A few years ago, I did have contact. My daughter did try to commit suicide, and I received basically 911 text to call. I reached out to see what was going on. My daughter was going through a rough patch. She had basically just a lot of anger issues, and I basically contacted to see what was going on, and I rushed to the hospital.
How old is your daughter now?
She's 22. She's presently here. She's my main supporter.
She's, yeah, she is presently in my conference room with us in support of her father's application.
So what caused the protective order to be issued?
Going through a divorce process, it stemmed from a breach of peace. I was never have ever gone into a divorced situation. Giving 14 years of my best, I was seeking answers. We were in court, and I was just flabbergasted what was going on through the divorce and being handed. I asked her, "Why are you doing this? We're going to lose everything." So it was a statement that I deeply regret. I should have never gone up to her and stated that to her. But keep in mind, I was never ever violent to my wife. I believe in family. I believe in God. And unfortunately, this was an emotional decision I had made. I was going through duress stress.
I'm a little bit confused because my understanding of the December 2009 incident is that you were in court and you violated the protective order by going to the family relations window and the victim advocacy office to have contact with the victim. So the order was already in place, and I'm trying
Yes,
to
ma'am.
understand what precipitated an order to be issued.
A breach of peace, ma'am. Argument.
Courts don't issue protective orders for nonviolence.
Yes, they do.
Yes, they do.
Unfortunately, on a breach of peace.
I can speak to that. I do. I'm in criminal court 4 out of 5 days a week. I do a lot of family violence. If it's domestic related, I see it all the time.
Mr. Rodriguez, do you have any questions?
No, Madam Chair, I don't.
Ms. Chance?
I don't have any, Madam Chair.
So
Madam Chair,
I need,
I'm so sorry. This is Nina from the Office of Victim Services.
yes.
I do have the victim of this case here with us, and she would like to address the board members.
This would be appropriate.
To the victim of this case, this is your opportunity to unmute yourself, and if you would wish to turn on your camera, you may do so as well. It is your opportunity to address the board members and just the board members. Thank you.
Good morning, board, and good morning to everyone who is present during this hearing today. I am glad to hear that Mr. Bryan is making a decision to reinstate himself in society. However, I am here to continue to address the issue that as he's smiling right now, his daughter's sitting right next to him, and his violence conduct has not ever deceased. Number one, just a few years ago, let me just backtrack here for a second. During the troubled times of my daughter, he's never taken her to the hospital. I have. And just 2 years ago, after my daughter decided that she was going to go with him, ultimately my adult daughter at that point, and ended up going with him, he got into an altercation with her where she ended up with blunt trauma to the chest, concussion, stitches. There's plenty of proof and records. This case was seen. Both of them got arrested. He claimed that she had punched him on the face. And as a result of that, because she was in his house, he reached out to me for me to control my daughter. So I picked up my daughter, drove her to the hospital in the middle of COVID with severe injuries as a result of his continuous acts of violence. Now my daughter is an adult. Yes, she just texted me a little bit ago. As I asked her, I need to know if you did write a letter on behalf of your dad. I did ask her that question so that I can be fully prepared, because I knew that this moment was going to happen, and I knew that he would use everything in his power to make sure, as he has always done, use his child to be the cause and interference between what he can and cannot do. With that said, he dropped the charges on his daughter. The office that represents him, representing his daughter as well, with a different attorney in the firm. And as a result of that, because he felt that that was the only person who can control his daughter was myself, I didn't pursue the violation that he was facing at the time for the order again. Fast forward to all of this just 2 weeks ago. There's been plenty of conversations. I speak to my daughter all the time. And the only thing he always does is ask, what's going on with your mom? Whether that's good intentions or bad intentions, I do not know that. But what I do know is that I oppose 100% to this pardon being accepted by this board, as I know that his actions have not been transformative in any way, shape, or form. He does not contribute to his community, and he knows that very clearly. He knows that in these years of being together, that we have been separated, and I have been married with my children, with children from my new marriage. He has not stopped his continuation of manipulation. So I completely oppose to this board accepting this pardon. And I make it very clear that the fear continues to be there. And if I have to address this court one more time, in 2019, my daughter had gone with him, and my daughter asked him, have you ever tried to or thought about hurting my mom? And he described in detail how he would kill me, how he will make everything disappear and go back to his home country of Colombia. My daughter just texted me a little bit ago saying that we are the reason why she goes to therapy, and we are the reason why she takes medication. If this is manipulation, I don't know what that is. But I will say to this court, the fear continues. I have been very strong on this case since day one, and I will not desist of this protective order. The paper is not going to stop him from hurting me. Let's just be very clear. It's not going to. But what it is clear is that he will continue to use whatever resources he can and has to lie to the court, as he did in this statement, and continue to pursue his life as he claims that he is in Chicago, but spends most of his time on the weekends here. Now my daughter has a child, and this will prohibit me completely from being a part of this child, because every function, anything that happens, and he's present, I will not be a part of that.
Thank you for your statement. Thank you, Ms. Vasquez.
Thank you, Madam Chair, member and panel.
Thank you to the board, please.
All right, so Ms. Chance, where are you in this case?
I do hear, what the victim is saying. I wish we had some documentation about what happened 2 years ago.
Okay, I think the only thing that we can consider is that her input was that she continues to be afraid and is opposing the granting of the pardon.
Right. The information that she has shared as to why she's opposing it appears to be a continued threat to her safety. And I do appreciate the fact that the petitioner lives in another state, but as we know, there is no guarantee for that. He did indicate some counseling, but just hearing the victim speak today, Madam Chair, I would not be in favor of the pardon today.
Okay, I just want to point out that in the application summary, he does identify as a Connecticut resident. Mr. Rodriguez?
The victim's statement was very powerful for me, Madam Chair. And although I see that Mr. Byron has done some work and done some good work, and in fact has gotten some good letters of reference, it seems to me that the victim's statement was very powerful, and I'm not there today either.
So would either of you like to offer the reasons? I'm hearing 6.
Well,
so
I'm hearing 6.
It would be
absolutely
6 and 12.
as well as 14?
And the standing, yes.
Oh, the standing criminal corrective order, yes.
So in the matter of Jose Bryan, there's a motion to deny an absolute pardon due to the injury and impact to the victim, as well as the serious nature of your offenses would be diminished by expungement of your criminal history, and you have an active standing criminal protective order against you. Mr. Rodriguez,
Aye.
Ms. Chance,
Aye.
the chair votes aye. The pardon is denied.
Hello? Where'd they? Hello?
Next on the docket, we have Julio Enrique Negron, represented by Attorney Ruane's.
Well, if that wasn't a fitting ending, we have the hot mic there by the moderator, or what she does, and the attorney trying to say like, hello, hello. And oh man. So I'm conflicted with this hearing. I am. I think for one, talk about before the attorney fell on the sword. In this case, I felt like maybe the attorney pulled out his sword and put it through his client, because what are you doing? You're telling the parole board. It means you really have no idea how this process works. You're going to go and tell the board, no, I know it's possible. I go to court 4 times a week and see it. It's like that's not an attorney being an attorney. You would pull out like some like a legislation or something that allows it, something more than I've seen it, because the parole board, this is what they do all day. This is their life. Don't tell them how things work. That could have been the end of right there. The reason I'm conflicted on this is because, like what Miss Chance was saying, if only we had some records. We have his scorned ex-wife who basically said a bunch of things that weren't, one, I don't even think pertaining specifically to the case, never that it was like violence against her, never that it was, I didn't hear that. And we have his daughter that actually is siding with him, adult daughter now. The only thing that I think we have is the idea that he has the one with the protection order, 99 years, which is really intense, like a 99-year protection order. But even then, the idea that how he got it, they didn't describe how he exactly received it. There's some confusion whether he already had it and then in the divorce court went there to say something, or if that was what gave him it. But again, it's not like we have seen so many cases where there are protective orders and you can say, okay, this is clearly dangerous. This is clearly scary. And I didn't see any of that here. And I know that some of you may rightfully so, because maybe I'm just not seeing it clearly, would say, no, man, dude, no matter what, you have to take the side of the victim, of the survivor. Clearly, he's a manipulative guy who is, really dangerous, and you have to believe everything that she's saying, and we have to go with it. And at least just to be safe, like, again, it's a pardon. This isn't about getting parole. Pardons are special. Let it be, let him reapply with the paperwork. Okay. With that argument, I can agree with you. Play it on the safe side. On the flip side of that, man, it just seemed like there was a lot, he didn't do himself any favors. But if his daughter wasn't sitting with him, I'd probably feel very differently, but I'm just confused about it. The thing, it was confusing. I mean, we see where Connecticut grants, like, really just like, ooh, here's a pardon, here's a pardon, here's a pardon, here's a pardon. But you know what? I guess I talked myself out of it. The bottom line is he can always reapply. He can get better representation. He can be better prepared next time if he truly is innocent. And maybe that was his wife, you know, doing a real mic drop and standing up for herself. But the whole bottom line sadness is that she doesn't, you know, their poor daughter is stuck in the middle between two of them. They have a grandchild now that is stuck in the middle between two of this, and the whole thing is a disaster. And it's 15 years later, and it's like this. No. Well, we saw pardon hearings from Louisiana. We saw from Connecticut. I think the contrast couldn't be any more different. And you really can get an understanding of how I think a state operates by watching parole, commutation, and pardon hearings. Thank you, Richard, for all the research and help into putting this together. And with that, I'll let you go.